I'm Ben Meiselas from the MeidasTouch Network. The Department of Justice has just filed a legal brief in the D.C. Circuit Court of Appeals, where the Department of Justice has made clear its position that Donald Trump should not be afforded absolute immunity for his conduct on January 6th in connection with the insurrection as it relates to the filing of civil lawsuits for monetary damages against Donald Trump. This brief that the Department of Justice filed is referred to as an amicus brief, which translates to a friend of the court brief, and it was requested by the D.C. Circuit Court of Appeals in connection with a case that was before it. And you may remember that multiple lawsuits were actually filed against Donald Trump by members of Congress, as well as Capitol Police officers for the injuries that they suffered and experienced as a result of the January 6th insurrection that Donald Trump incited. That lawsuit was filed before a federal court in Washington, D.C., got assigned to Judge Amit Mehta. Donald Trump filed a motion to dismiss under Federal Rule 12b-6, essentially asserting that there is absolute immunity for the conduct of presidents during the term of their presidency, even if their conduct could potentially be construed as unlawful or illegal or even inciting of violence. And one of the cases that Donald Trump cited was a 1982 United States Supreme Court case, Nixon versus Fitzgerald. And there, the Supreme Court held that United States presidents during their term in office should receive absolute immunity when they act within their constitutional powers or prerogatives, even if it's within the outer limits of their constitutional power and prerogatives, even if it's unlawful acts, but still within the outer perimeters of their constitutional powers and prerogatives. And just for example, the Fitzgerald case was a wrongful termination lawsuit filed by Fitzgerald, an employee, government employee, against Richard Nixon for retaliating against Fitzgerald for being a whistleblower. And there, the Supreme Court ultimately ruled that the case brought by Fitzgerald should indeed be dismissed because of the absolute immunity afforded to presidents during their term in office, even if the conduct was unlawful, because of the fact that a president has hiring and firing authority. That's within the scope of their constitutional powers. So even if it is unlawful, there is no liability there. Then came a case before the Supreme Court in 1997, Clinton versus Jones, involving accusations of conduct that President Clinton engaged in before he was in the White House. And there, the Supreme Court said that the holding in the Nixon versus Fitzgerald case does not apply. There's no absolute immunity for conduct that occurs before a president is in office or after the president is in office. The absolute immunity applies during the time when the president was in office. So Donald Trump was arguing the conduct that I engaged in on January 6th, I'm in office, even if you want to argue that it's potentially unlawful, is subject to complete immunity under the Nixon versus Fitzgerald line of cases. The district court judge, Judge Amit Mehta, several months back, rejected Donald Trump's motion to dismiss, denied it. So Donald Trump appealed it to the D.C. Circuit Court of Appeals. There was oral argument held within the past few months there. And following the oral argument, the D.C. Circuit Court of Appeals requested the Department of Justice file this brief, this amicus brief. What is your position, Department of Justice, on this issue of absolute immunity? And now the Department of Justice is answering that question, that inciting violence is not subject to absolute immunity. That doesn't even fall within the most arguable outer limits of what presidential authority is. And the Department of Justice state in their legal brief that the district court judge, Judge Amit Mehta, got it right. So let me read from you some of the portions of the brief that was just filed by the Department of Justice so you can see their argument for itself. The Department of Justice says on page 2, the United States expresses no views on the ultimate conclusions or the facts that are being asserted in the underlying complaint brought by the plaintiffs. Remember who the plaintiffs are again. The plaintiffs who filed the lawsuit against Donald Trump, members of Congress and Capitol Police officers who were injured. And then the Department of Justice says, but in the United States' view, such incitement of imminent private violence would not be within the outer perimeter of the office of the President of the United States. If it fell within the outer perimeter, then Donald Trump would have absolute immunity. But here the Department of Justice is saying that conduct does not even fall within that outer perimeter, and the district court got it right. Let's turn to page 3. On page 3, the Department of Justice says, in this court, President Trump has not challenged the district court's conclusion, reiterated by plaintiffs on appeal, that the complaints plausibly allege that his speech instigated the attack on the Capitol. Instead, his briefs advance only a single categorical argument, and here's what it is: that a president is always immune from any civil lawsuits based on his, quote, speech on matters of public concern, even if that speech also constitutes incitement to imminent private violence. The United States respectfully submits that the court should reject that categorical argument. And because that is the only argument the former president has pressed on appeal, the court could affirm the district court's order on that narrow ground without attempting to comprehensively define the boundaries of the president's immunity for his speech on matters of public concern, including when and how to draw a line between the president's official and electoral speech. So why is the Department of Justice using such careful language? Well, it's very important. You know, the Department of Justice is part of the executive branch. Their job is actually to protect Article 2 powers of the presidency. But Donald Trump's conduct in inciting an insurrection is so unprecedented that it comes into conflict with what the Department of Justice would normally have to argue, which is to try to protect presidential powers. So what the Department of Justice wants to avoid is having the court reach categorical conclusions that could actually erode legitimate powers of the president. Like, how do you separate the division between campaign speeches and the functioning of a president? Can you draw categorical lines there without, in the Department of Justice view, weakening the role of the president? Or can you or should you draw categorical lines as it relates to the fact that January 6th related to the certification process, which is not within Article 2 powers? Wouldn't that erode the powers of the presidency, which the Department of Justice and no Department of Justice wants to do, because their job is to pretty much do the exact opposite? So here, the Department of Justice is arguing, let's focus on what the narrow ground at hand is. The narrow ground is Donald Trump is arguing that a president is always immune on matters like this, even if it is the incitement to imminent private violence. And if that's how it's defined, and that's how Trump wants to define it, that doesn't even fall within the outer limits of what the powers of the presidency is, because that's reiterated on page 15, section 4 of this brief, which says incitement of imminent private violence is not within the outer perimeter of the president's office. And it says the district court also correctly rejected President Trump's categorical assertion that whenever and wherever a president speaks on a matter of public concern, he is immune from a civil suit, even if that speech also constitutes incitement to imminent private violence. Speaking to the public on matters of public concern is a traditional function of the presidency, and the outer perimeter of the president's office includes a vast realm of such speech. But that traditional function is one of public communication. It does not include incitement of imminent private violence of the sort the district court found that plaintiffs' complaints have plausibly alleged here. Now, I've been reading some of the comments and how it's been reported. To be clear, the Department of Justice has not ruled that Donald Trump does not have absolute immunity. The Department of Justice is not a court. It does not make rulings. Ultimately, the D.C. Circuit Court of Appeals will hear this argument made by the Department of Justice. It will hear the argument that was made by the lawyers for the plaintiffs, the members of Congress and the Capitol Police. It will hear the arguments made by Trump's lawyers. It will be the duty of the D.C. Circuit Court of Appeals to ultimately make a ruling. The D.C. Circuit Court of Appeals wanted this brief from the Department of Justice to help it make its ruling. No matter what, after this ruling by the D.C. Circuit Court of Appeals, I can absolutely guarantee you it will go to the United States Supreme Court, and they will ultimately have the last word. They will be the ones who rule. And while the Supreme Court has made a lot of rulings, which I don't agree with, generally, when it's come to issues of Donald Trump's kind of outrageous big lie related conduct, they have not been supportive of that conduct, even if they've supported a very strong right-wing agenda on almost all other issues, because you have 6 right-wing Supreme Court justices, 3 of whom were appointed by Donald Trump. So that's what took place with this filing by the Department of Justice. And I guess one other thing to point out, in a footnote on page 3, footnote 1, what the Department of Justice also wants to make clear is this analysis that we just went through and the Nixon versus Fitzgerald line of cases, that relates to civil damages. That's what we're talking about, civil lawsuits. And they want to make this distinction because they are criminally investigating Donald Trump. And when it comes to criminal investigations and an immunity of a president in criminal investigations, the intimation, if you will, by the Department of Justice is that absolute immunity framework does not apply when we're dealing with criminal conduct. They don't go outright and say it, but they want to be clear here. We're not talking about standards at all. In criminal cases, we're talking about civil damages. In criminal cases, again, the Department of Justice doesn't say this, but they hint at it here that their rights of prosecuting presidents for crimes is a whole different framework, and they don't want the Nixon v. Fitzgerald and this case right now against Donald Trump to in any way become precedent that in any way harms their criminal investigation. But you see how thoughtful, how careful they are being, and now from watching this video, you know why. I'm Ben Meiselas from the MeidasTouch Network. Hey, hit the subscribe button. We're on our way to 1 million subscribers thanks to your incredible support. We are marching to 1 million subscribers in the month of March. So please hit the subscribe button right now. And also check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. I think you'll love the content we have there. And make sure you subscribe to the MeidasTouch podcast wherever you get your audio. Just search MeidasTouch podcast and make sure you download it and subscribe there as well. So subscribe to the YouTube channel, and thank you so much for watching this. Have a great day.
Love this video? Then you'll love the MeidasTouch podcast. Listen as my brothers and I break down the latest news and chat with top political leaders on the fastest growing pro-democracy podcast in the world. New episodes drop every Tuesday and Friday. Add the MeidasTouch podcast right now wherever you listen to your podcasts.